Hey, I guess I don't know why I'm reading the comments as they float along and forgot to say good morning, Mike. Good morning, everybody. Well,
good morning, good morning, good morning.
Welcome back to Law and Legitimacy. How's the weather down there in North Carolina?
It's a balmy 40 degrees here this morning, uncharacteristically cool, but we had a lot of rain,
Well, Noah's coming. Get that ark ready, 2x2, get the animals ready and try to recreate the world. New Haven, a little chilly, but you know, it's spring, so what do you expect? Lots going on in the world. Don't even know where to start. I guess I should, since I've mentioned marital difficulties in the show, my wife and I are trying to patch it up. It's the right thing to do for all sorts of private reasons, because I leaked it out on air before that there were difficulties. I leak out now that two people of enormous goodwill and love can recover from mistakes, and I certainly am a man capable of them. On that topic, what about Judge Juan Merchan? He is he's way out over his skis. He's apparently asked the press to not report on public events regarding jurors for fear that reporting will yield information that can identify members of the press. Yeah, I saw this headline: Hush money judge cracks down on media over juror fears of being exposed. He has no right to crack down on the media. And so I don't know what he's thinking. If you're, there are conflicting values at play in the Trump trial. The people of New York have obtained an indictment of Donald Trump. That is their right. The people of New York are pursuing Donald Trump because he didn't disclose truthfully, in its view, in the people's view, certain expenses, and he mischaracterized them. And the result is that hiding the hush money payments to Stormy Daniels by characterizing them as legal fees to Michael Cohen resulted in fraud, and the legal definition of fraud being a misstatement of a material fact. And so the claim is that Trump didn't disclose the payments. Apparently, Michael Cohen had to get a home equity loan, and then he paid Stormy, and then these were characterized as legal fees when Donald paid him back. I don't know if that's a crime or not. I don't know what a jury is going to think about that, and we'll find out. But now, of course, the former president of the United States is facing a criminal trial, first time ever in American history that a president has done so. Okay, I get that. Everybody's interested. It's a non-publicized proceeding. The people of New York have a right to prosecute Donald Trump. I get that. He doesn't have immunity given his status as a former president. Everybody's equal under the law. I get that. Trump, on the other hand, has certain constitutional rights. He has a Sixth Amendment right to a speedy and public trial. The press and the people at large, meaning us, we have a First Amendment right of access to the courts. Judge Merchan has a right, or has the responsibility, the inherent judicial responsibility, to assure that a fair trial takes place. Where does that put reporters? So reporters, if you can get a seat in the courtroom, and I gather they're assigned by lottery. If you can get a seat in the courtroom, good.
Yeah, according to Joe Neerman, the following pro, because I think on the stream last week or late the week before, I talked about something that he had gone live on his own X account and talked about the fact that he's got his press credentials. He showed them, and I think he was actually in Manhattan in front of the courthouse, and he had just come from there, and because he was speaking with the head of security, because apparently the demand by the press to be in whatever the press room is in the courtroom, and then there's like an overflow room. Apparently, that is insufficient to allow access to all of the press credentialed individuals who'd like to be there to report. So there's an additional, I guess, an overflow room, but it's known within the court norm that there is insufficient room. And then, of course, I don't even know that it's necessarily by lottery, right? As you suggest. I could be disproven on that, but I don't know whether it's lottery or first come first serve, or if there's some other way to shoehorn one's way into the press gallery.
Well, so and there was an overflow room certainly in the Proud Boys case. This was a very large courtroom, and so there was a video feed to a room downstairs where reporters could sit and watch. And I gather that was probably a fun place to be because they could watch the proceedings and comment on it among themselves as we watched it. It would have been nice to see the color commentary on my own performance. Maybe it would have been nice. It might have been devastating. Who knows? But I think that because there is that famous line from Robert Burns, oh, would that gift, the gift he gives, to see ourselves as others see us. In other words, the gift of what your blind spots and what's out there that you can't see. I think though that the thing that's troubling to me about this, and Mike, I don't know what your perspective is, there is no right. The court has no right to issue a prior restraint on journalists. Merchan just can't tell. Like, he can't crack down on media over juror fears of being exposed. That's just that doesn't correspond to my sense of what the First Amendment means. If the court has taken steps to assure juror confidentiality, and I've seen that done. You're juror number one rather than John Doe. If there are going to be pictures taken in the courtroom, you can't take pictures of the jurors. So, for example, in Connecticut, where you can get live streaming of trials, the court never lets jurors' images be live streamed or televised because they want to take steps to ensure juror confidentiality and to avoid the sort of influences that can be brought to bear on a jury. So I get all of that. I think that
yeah. So I guess my question is more of a threshold question because cameras in the courtroom is complicated, right? But as I understand it, New York is one of just a handful of states that bar the use of cameras in the courtroom. How many? I think I was reading 2 or 3 states out of 50 that still bars the use of cameras in the courtroom. So that's interesting to me. I don't know what the justification at this point is for that. It starts to look pretty hard to defend, I'll say. And then the other part of this is that we talked last week about at least one of the jurors going home and having members of his or her family and colleagues and friends basically guess that they were a juror based on the way that the media was reporting. And I think I was pretty outwardly critical of the way that the media went about that. So part of it is, ultimately it's as if there are 2 things wrong here. Number one, the court is having to respond to a press that seems unguided by any sort of, disciplined principles within the profession at this point, which, hello, Mike, welcome to 2024. I get it. I don't mean to sound as though I'm not, I can't observe over the last, decade what's going on. But I think that what I am saying is that what is Judge Merchan to do if we already have at least one juror who is, being revealed by and through, friends and family and colleagues as being a part of the jury pool, right? So there is that. But then on the other hand, it's, is there not a better way to give the press what it wants? Because the press wants information about this case. This is one of the most popular cases in the United States, in the world right now, right? And I think that that's not a stretch to stay in the world. So what is it? Why can this case also not set new precedent as to allowing cameras in the courtroom. I understand it's a matter of state law, but to me, there is a demand that will be fed one way or the other. So to put Judge Merchan in a position where he has to start, telling the press, don't do things, use common sense, you can only report on what's in the record, right? Well, that doesn't mean anything to this press class, right? There is no such thing as common sense among this press class. And, no unintended disrespect. I think I have plenty to say about the modern press, but there is a demand for information about this case. So it's as if this is set up to fail. It's as if those jurors who are a part of this need to think and feel a certain way so that there isn't an impetus to reveal who they are. And I don't think I have to say anything more about that.
No, but I just, the input. So, their identities are not known. The jurors can observe them. The press can observe them. The press knows their characteristics. If you're absent for work for a second, third, fourth week, and commercial lawyer, and you happen to be your colleagues are going to figure it out. And then if your colleagues are going to call you and say, we don't like Trump, or we love Trump, then you have to report that to the judge. And it's possible in this case that the trial ultimately fails because of extraneous influence on the jurors. Now, one solution to this would have been to put the jurors in a bubble and to sequester them, to keep them in a hotel room, but that's almost cruel to deprive people of contact with their families. I don't know what the solution is. I just know that Merchan's effort to impose a gag order on the judges is a likely fail. And there you have it. There'll be opening statements today. Those of you who aren't lawyers are probably used to the television portrayal of trials, and in a television portrayal of trials, you rarely really get any insight into jury selection. Jury selection is a highly idiosyncratic process, and no two lawyers probably do it alike. It's like watching a relationship form. That's largely a question of imaginative interpretation of the relationship between two people. There's not much to see, as it were. The business of opening statements, though, is that is usually a short and plain statement of what you intend to show in the evidence, what you think the evidence will show. It's not supposed to be argumentative. Connecticut, by way of example, doesn't give opening statements in civil or criminal cases. It's unique in that way. We have individual sequestered voir dire. That is, we can question each juror individually out of the presence of others for as long as we like, or as long as the judge will let you get away with it. But then you don't do opening statements. So years ago, a brand new prosecutor came into Connecticut from another state, and after the jury was selected, she stood up and started to give an opening statement. So I let her talk for a few sentences before she did this before calling her first witness, and I let her talk for a few sentences, and then I said, "Judge, may we approach?" I said, "Yes." I said, "I'd like a mistrial. This shouldn't have happened." He said, "You're right." And so the trial process just blew up as a result of this simple misstatement. And the week or so that we'd spent picking a jury was for naught. Because this lawyer apparently didn't know the rules of the road in Connecticut. In New York, I don't know what the time limits will be for opening statements. I looked through.
Well, let's start here, because I certainly want to know how defense team leader Norm Pattis would approach opening statements. But as it's reported, Will Scharf, one of Trump's lawyers, has said that the strategy here is going to be to, quote, focus on the facts that are exonerative of the charges that have been levied. Quote, this case obviously should have never been brought. He said, quote, there are a lot of aspects of this case that are highly, highly irregular. We're seeing prosecutors who are hell-bent on interfering with the 2024 election, bringing these unprecedented legal theories against Mr. President Trump, all because of what he's doing, because he's running for president. It's an outrageous abuse of the legal system. So that's just, that was a statement that Will Scharf gave to Fox News. He says to emphasize the facts, to focus on the facts. Now, from where I'm sitting, I'm not sure that I'm, very compelled by words on paper. Maybe the inflection was different if I heard it out loud. But Norm, what would you focus on for opening statements?
Well, first, let me comment on Sharp's comments. I don't know. There are facts. There, in other words, things that occur in the world that people will agree have occurred. the Knicks lost a ball game, the Yankees won a ball game. And then there are facts that are material and relevant to a case. That is, facts that tend to show that an event either occurred or didn't, and facts that matter. So, the color of a car may not be a material fact if everybody agrees that a given car hit someone. If the identity of the car or the driver is an issue, the color may matter. So that's a different, materiality. In this case, if I'm Judge Merchan and I'm in New York, which does not permit jury nullification, the state's motives for bringing the action are neither material nor relevant. And so I would preclude the defense from arguing that this case was brought for political reasons. And my prediction is that that's what Merchan is going to do, because it's often the case that in a criminal case, obviously the defendant's motives for acting are material and relevant. Judges will say the state's motives for bringing an action are not. And the defense response is, wait a minute. The state brought this action through its agents. Their motives are material because motive is never collateral. That is, motive always matters for a party in an action. And, when I've tried to argue that in various courtrooms, in various cases, judges have kept the state's motive out of evidence. So I think it's entirely likely in this case that comments about the state's political motives for bringing this action will not see the light of day in courtroom. And I expect.
So to his point, though, he did say that, bringing the facts attendant to this prosecution are highly, highly unusual. And so I think that, maybe the implication, right? Because I hear what you're saying. I think that Judge Merchan doesn't have a choice about that. What is he going to do? Just allow the Trump defense team to spend time trying to build up the narrative that this is all politically motivated? I don't think that advances the underlying causes whatsoever, nor do I think that he has the stomach to do that anyway. But more importantly, I think that perhaps the defense has to know that, right? And therefore they would at least have a theory that implies political motive through a showing of what, right? Other things. So if he's saying that it's highly, highly unusual, I think that that's what we've been talking about for weeks and months at this point, right? That there is what is historically a misdemeanor charge being enhanced to a felony charge, right? And we still don't necessarily know if the foundational conduct in and of itself was criminal. And then the additional question is, why wasn't Stormy Daniels, also criminally prosecuted for her role in whatever that underlying alleged criminal conduct would have been?
But these facts are not material, in my view, in this case. And so the question will be whether the documents that Donald falsified fall within the meaning of the statute that prohibits the falsification. And whether he engaged in hiding surreptitiously the true nature of these payments. That's going to be the case. And so Merchan, a trial judge, when an appellate court reviews the decision of a trial judge on matters of evidence, they do so under a very deferential standard called the abuse of discretion standard. I think that Merchan is going to have to. He's going to be given a tremendous leeway to sculpt the case. He's a smart guy. I think I've mentioned to listeners before, I appeared before him in the Soccer Mom Madam case a dozen or so years ago. I think that he will make some some discretionary rulings. Maybe a little more of this stuff will get in than I suspect. Maybe a lot less than I suspect. But if he's the judge I think he is, the focus is going to be on the documents, Mr. Trump's intention in having those documents filled out the way they did, and whether that intent amounted to fraud. That is the narrow case. So opening statements, it's interesting that there are a couple lawyers on the jury. If I have an actual defense that requires a sophisticated understanding of the law, for example, self-defense, which in Connecticut until recently was a very complicated jury charge, I will pick a lawyer on the theory that they will understand the charge and have the ability to get a jury to focus on it. So when you see criminal defense lawyers pick lawyers for a defense, that's usually a confident defense team that thinks it has a legal position that another lawyer will understand and be able to determine for a jury. And so I think that's a very good thing. And so I expect the opening statements to be something along the following lines from the defense. You know, the state of New York brought these charges. The state of New York brought these charges for reasons that you may or may not hear in this case. And then pause and smile and let the jury connect the dots. Look at all the precedent here. Then the next line, the former president of the United States, the presumptive Republican nominee, is here on trial in a Democratic stronghold. Objection. Okay, but you take the objection and move on. You've made your point. You've reframed the issue. I want you, ladies and gentlemen, to focus on the allegations in this case. Yes, Mr. Trump had a relationship with Stormy Daniels. La-di-da. That's not what the trial is about. The trial is about how money paid to her to keep this secret was reported on public documents. Moreover, it's about Mr. Trump's intention in having them reported in that way. To convict, you'll have to prove first that he knew how it was reported, second, that he authorized it or endorsed it, and then beyond that, if you conclude that he did, you'll have to ask whether these were really legal payments or personal payments or whether they violate campaign finance laws at all. We suggest they're not. Mr. Trump's, again, the motions in limine, the motions at the threshold about what of Mr. Trump's prior conduct comes in matter. I haven't followed them all. I'm not Joe Neerman at Logic. You should follow his feed for a more in-depth reporting of the case. I just don't have the time. Neither does Mike. We've got busy practices of our own. But I think what you want to do is you want to get as close to saying that Trump, even if he knew about these payments, did it not so much to hide this from the general electorate, but to avoid embarrassment at home. And then the prosecution can say, well, if it's both, he's still guilty. You may not want your wife to know, okay, I get that. And you may not want the world to know, I get that. But as long as your intention was to keep it from the world and you mischaracterized it, you're guilty. And that's the knife edge, Mike, on which this case turns. And I don't know enough about the facts or candidly about New York law. I'll be curious to watch the evidence unfold to see.
I don't know that you're in the minority with that. Even among the legal community, I think that there are plenty of people that could talk procedurally about how these things go. They could talk more, in better detail about, press access to the courts and, what the standard is there. But I don't know that there is very much known at this point. And there's no shortage of op-eds on both sides of the political partisan line with respect to, the bringing of this case. The reality, though, is simple. This is a criminal prosecution. It's not as if Trump has the ability to just ignore it and continue campaigning. The issue of him being present in court was, brought up last week on this stream, and could indicate some clear consequences to Trump for not being there and being present through the duration of the trial. One question I have, Norm, for you is, I guess, more of a gamble or a wager. Does he testify?
So that's a great question, and so I want to.
I know, because I don't know. I think that,
and neither do his lawyers. Look,
well, I baited you a little bit. I baited you a little bit because I think that what I'm reading now, the New York Sun, A.R. Hoffman has a great piece on this. But there's I think a growing concern that let's skip ahead, for example, and let's say that even if Trump is meritorious, or even if he's not, but he's elected in November. Would his testimony in this case be used as yet a third impeachment effort? Right. Right. So from that perspective, I mean, I think that there is a very difficult decision to make if you're his defense team here and if you're Trump as well.
Let's stop. It's not a team decision. So look, here's the law. With respect to the role of defense counsel in a criminal case and the role of a client in a criminal case, there are certain rights that belong to the client, absolutely, and he in his decision binds. That is whether to plead guilty or not. That is whether to have a jury trial or not, and that is whether to testify or not. Now, you hire a lawyer to advise you and to try your case. The lawyer presumably knows the law, masters the facts, and then tells you do this rather than that. Yada yada yada. The decision to testify belongs to a client alone. And so the lawyer may say, look, Mr. Trump, you shouldn't testify. If you testify, they're going to impeach you 6 ways to Sunday with the following events, and the judge has determined that they're admissible, and it's going to lower your in the estimation of the juror's mind, and you're more likely to be convicted. Trump can say, I understand that, but I want to testify. And so clients sometimes testify against the recommendation of their lawyers. And so typically, the decision on whether a defendant to testify is one of the last decisions made in the case. A prudent defense lawyer obviously will listen to and attack the state's case, and that prudent defense lawyer will then listen to and put on his own case. And then at the end, you make an evaluation of what the pros and cons of your client's testimony are, and you say and you give your client your best evaluation. And sometimes you're wrong. Sometimes you've misread the jury. Sometimes you don't know what they're going to do. But always it's the client's call. And so, Trump is saying he's going to testify. He's a bull in a china shop. He doesn't strike me as the kind of guy that says, hey, Mike, I can't decide whether to testify. I'm going to follow your recommendation. I think that Donald says, here I am, deal with it. I'm a tidal wave.
Yeah, no, I think that he has to, because I know that in terms of if we take more of a meta approach to viewing these events, right? His defense from the civil suits as well as the criminal prosecutions here are in essence his campaign. And to the extent that there are no cameras in the courtroom in New York, that the press must only report on what is in the record, he is going to absolutely have to testify if he is going to use this trial for any productive campaign efforts. That's just the way I look at it. And I think that he is going to rely on the conservative press to report on court documents, right? Court records, what is transcribed into the record. He's going to rely on that press to counteract any sort of developing narratives from the political left. And that to me is just a strategic decision. Outcome be damned, and long-term consequences be damned as well. I think the point of this case is to win on some ground, right? Whether to be found not guilty and or to at least make some hay while the sun is shining with respect to press attention and media availability.
So the following occurs to me, and this is something I've not thought about before, so don't hold it to me. And folks, we don't actually elaborately prepare for these shows. You may have intuited. Sometimes the best ones occur live, as this one does, the best thoughts. So maybe Trump gambles as follows. What I want most is to win the general election. Mm-hmm. This trial is free publicity. I'm going to testify. And if the judge stops me, I'll continue, and I'll make him hold me in contempt, and I'll say to the American people, this is what they're doing to me. They want to do to you. Get me in office. And that'll play in some quarters. And then let's suppose he gets convicted and he runs. This might be Trump's fantasy. Let's suppose he gets convicted and sentenced, sentencing. I don't know what the standard is in New York. Usually it's 6-8 weeks after conviction. And let's say the judge locks him up or doesn't. Donald may be thinking that if he wins by application of the United States Constitution, he can get the sentence deferred until after his term in office. Now, how old is he? 78? Is it?
Yeah, 78 or 79.
Nobody lives forever. You have to calculate. You have to make your own estimate of what the mortality table will hold. So maybe he concludes he'll get his 4-year run, and then if they want to lock up an 82-year-old, well, he won't have much more to live anyhow. And bam, bam, bam. I have no idea what goes through that man's head in the middle of the night. And candidly, I'm glad it's not my head, because my life is complicated enough. It's super complicated.
Yeah, very much so. Well, with the remaining couple of minutes here, do you want to transition quickly to the other item that we had?
Yeah, sure. So big events at Columbia. In-person classes have been canceled. There's now a tent city at Columbia. There's a liberated zone, an encampment on the campus where pro-Palestinian or anti-Israeli people have posted a tent city. That I defended the New Haven occupied tent city in New Haven back in 2008, 2009. The posting of a tent city is within a person's First Amendment rights on public property. There can be restrictions on that that are reasonable in time, place, and manner to assure the public safety. Columbia is private property, so that's got a problem. If it has these students removed by force, it'll further inflame the student body. If it leaves the encampment in place, it's going to inflame and upset other parts of the human body. You know, tonight my wife and I will be attending a Passover at a dinner at a local institution, and you know, there are some concerns given the rage of anti-Semitism in the world right now, whether that's going to place.
It's also being reported that Yale has started to make arrests as well. So I'm reading stuff filtering in this morning that the thing with Columbia is that there's an entire encampment there. I mean, you see it there on the screen. They're calling it, you know, quote unquote, the liberated zone. But this is indistinguishable from my perspective to, you know, the Capitol Hill autonomous zones and what we saw during the summer of 2020 when various cities were overrun. I think that this, you know, I put on the bottom there, you know, will the school be saved by the graduation bell? And I say that to say, you know, there are students on campus, but it's, you know, as we sit here, April 22nd, college, the second semester, spring semester doesn't have long yet to go. And if there are any real, you know, classes left in terms of, you know, normal curriculum to be taught, I would be surprised. We are, you know, headed into the exam season. So in terms of the usefulness or the focal point that, you know, the quad would otherwise be, I think that the decision here from the president is a practical one. It's one that doesn't require too long of a strategy to make a decision about, from my view, because students will go home for the summer by and large, and then the intersection of this protest with the student body will reach a natural conclusion. The question will be what will become of it in the interim.
Well, let's see. You know what? Tomorrow, Mike, let's talk. You know, it occurs to me looking at some of the comments, including photographies. Wasn't it amazing that the Yale Occupy movement all went away in time for graduation? Let's talk about that tomorrow. Because
yeah, I know you've got a story about that. Yeah. And that's why I brought up Yale as well, because I know, number one, that's, you know, within reasonable proximity to where you are, but also because you've got a history there with the previous movements. You know, it's tough to understand what is going on, but I know one thing, you know, banning TikTok is not going to fix this. So
no, I hear you.
And in large part, I think that these things are related. We don't really have time to trace the contours of that, but you know, this is the sort of thing I meant, you know, in previous streams when I said that my concern is that these sort of inorganic flames light, and we don't really have control over what happens, but they happen, and then we're forced to deal with them. Things that happen abroad geopolitically are manifesting here domestically with rapid speed and without very much predictability. So anyway.
True that. Well, folks, I think we've talked our way through another half an hour of your lives. There's a lot going on. You know, Mike, I gave you a review of a book that, you know, given your interest in TikTok, I'm hoping we could read. I want to highlight it to everyone because I do think there is something fundamentally wrong with our social and political culture. And the
article you sent me, I think, I don't know the title of the book, but maybe it's a review. The title of the article on nature.com is called "The Great Rewiring: Is Social Media Really Behind an Epidemic of Teenage Mental Illness?" I think the
title of the book, Mike, is just below the headline. I know you didn't get a chance to read the article.
No, I didn't even click the article.
The Anxious Generation: How the Great Rewiring of Childhood is Causing an Epidemic of Mental Illness by Jonathan Haidt. Haidt. It's called The Anxious Generation: How the Great Rewiring of Childhood is Causing an Epidemic of Mental Illness. I think it's a book. I think it's must reading, and I encourage everybody to take a look at it. I intend to get to it when I have time. Sometime in 2029. There it is. And
yeah,
you know,
I'll take a look at that article. We'll definitely talk about that tomorrow. I want to talk about the Title IX issue with the Biden administration making that go away. I think that's a huge problem for women and the entire history of the suffrage movement at this point. And so we'll get to that, and then perhaps we will talk a little more about the Yale Occupy stuff. Give you a chance to give
yeah, that'd be fun.
to fight.
All right. Well, see you all tomorrow, folks. Thanks for listening in. We want your support. We want you to spread the word. I believe that we're offering unique, non-ideological content driven in legal doctrines and common sense, that we're offering you a vantage point, a way forward in our deeply partisan times, because we're trying to talk to you about life as it's actually lived, as opposed to life as it's experienced on the internet. And we realize we appear on the internet, so it's a contradiction in terms. Hey, deal with it. Life is, and you sometimes just have to go with the flow. And Mike, how do people find us?
You can find us on YouTube, on X, and on Rumble at LawPod Daily. We're here every Monday through Friday, 8 a.m. Eastern time. You can also find, well, most days, and guys, I've slipped up I think a couple of days in the last week with getting the audio only uploaded after the stream to Spotify, Apple Podcasts, Google Play, Overcast, wherever you find podcasts, but it's there normally. So you can find us there. And Norm, I think I at least will be on Friday with Laid Back Law. If you haven't talked to
if I'm free, I'll do it. I don't know, but we'll see. Yeah.
Cool. So you can usually find us on Fridays as well over on Laid Back Law, and that'll be true this Friday, April 26th. But anyway, see you tomorrow, Norm. See everybody.
AMF, yo-yo.
See ya.